In my column on the ABI website on Monday, February 13, we are reporting a very interesting decision from the U.S. Court of Appeals for the Sixth Circuit. In that decision, the Cincinnati-based appeals court ruled that an equity receivership may not grant exculpations and grant third-party releases to non-debtors. I found the decision to be quite interesting because the Cincinnati-based appeals court, in proper circumstances, does permit Chapter 11 plans to bestow the very same type of exculpations and releases. That topic of third-party releases was much the subject of conversation in a webinar that went live this week on the ABI website. The webinar dealt with the very intriguing decision from the Third Circuit Court of Appeals, which directed the bankruptcy court to dismiss the Chapter 11 case filed by a subsidiary of Johnson & Johnson. And in that case, it was very much the hope of the debtor that the bankruptcy court would ultimately bestow the same kinds of exculpations and releases on the Johnson & Johnson parent and all of its subsidiaries. This webinar was populated by three outstanding professors of bankruptcy law. And I got to tell you, the discussion was, I think, the most interesting I have ever seen on a video webinar. For those of you who were unable to watch that webinar live, you can dial it up on the ABI website, go either to CLE or Newsroom, and you will find it. If you don't find it immediately, send me a message and I will send you the link. I am Bill Rochelle, the editor-at-large for American Bankruptcy Institute. I shall return same time next week with something interesting from the world of bankruptcy. Until then, be well, stay safe. Good day.